Thornell, Director, Arizona Department of Corrections versus Jones, 2023. Danny Lee Jones was convicted of the premeditated murder of Robert and Tisha Weaver and Catherine Gumina. Arizona must give the death penalty if there are one or more aggravating circumstances. The trial court found 4 mitigating circumstances: 1, long-term substance abuse; 2, drugs; 3, alcohol; 4, head trauma; and 5, child abuse. Alito writes the opinion with Roberts, Thomas, Gorsuch, Kavanaugh, Barrett. Sotomayor dissents with Kagan and Jackson. Alito writes that the Ninth Circuit ordered resentencing due to the Sixth Amendment right to counsel was violated. Jones stole the gun collection and killed a 7-year-old, the father and grandmother of the father. Jones knew Robert had $2,000 gun collection after spending a day drinking and talking with Robert. Jones knew he beat Robert to death with a baseball bat. Tisha watched Jones attack her great-grandmother. Tisha hid under her bed, and Jones dragged her and killed her with a pillow. Jones stole the guns. Arizona should impose the death penalty if there is one or more statutory enumerated agitating circumstances and no mitigating circumstances. There must be at least one circumstance for the person to do it, while there are no other issues that would have led or altered the mindset for the person to do the crime. The aggravating circumstances are committed the murder, motivated to kill by gain, murders are heinous, cruel, or depraved. The mitigating evidence for this case are as follows: abused as a child, started using drugs and or alcohol at 13 years old, father and stepfather were abusive, suffered head injuries. Jones's counsel submitted a report and had testimony from Dr. Potts, forensic psychiatrist, to identify mitigating circumstances. Reared in chaos, had head trauma, mental illness, genetically predisposed to substance abuse, felt remorse, and could be rehabilitated. Jones sought a post-conviction review based on ineffective defense counsel. He should have had an independent neuropsychologist instead of Dr. Potts. The court denied this because the courts remember that Dr. Potts was a very good expert and was defense-oriented. Jones filed a habeas corpus petition in federal court over ineffective counsel. The Ninth Circuit granted habeas relief, and Jones would not have received the death penalty if the courts considered the new evidence. The decision did not write the aggravating factors. The Ninth Circuit does not examine the aggravating circumstances, and it does not evaluate the expert witness testimony. It also puts too much of a significance on mental health conditions. Jones' new evidence did not reach the level of any new information that was covered in the previous case. Thus, his mental health is not a significant mitigating circumstance. The new evidence of abuse of alcohol and drugs at 13 years old, sexual and physical abuse are uncorroborated, not even proven with outside sources, and it was not mentioned. His mother and stepfather said they had not seen sexual abuse. His sister does confirm physical abuse, but not to the level Jones asserts. All of the evidence would not have changed the decision. Jackson dissented. The Ninth Circuit did evaluate all evidence. They did not have to evaluate mitigating evidence because that was not the basis of the legal argument. The Ninth Circuit should weigh all relevant facts. The Supreme Court is not the court to evaluate this case. Sotomayor and Kagan dissented. They agree that the Ninth Circuit was wrong to ignore the aggravating circumstances. They want the Ninth Circuit court to go back and evaluate all of the evidence.